Hi, everyone. So why has the defense for Bryan Kohberger questioned the grand jury service process? The court audio was so hard to hear. So I'll just go through the points that I found most relevant, and then we can chat about the update that just took place where Bryan Kohberger has waived his right to a speedy trial. So, as most likely, it was a result of what we're going to be talking about today, as the judge in this hearing we're talking about said that they must push forward. It was a very tight schedule that was due to start on the 2nd of October, 2023. So the defense and they have challenged the grand jury, and they wanted this court to stay the proceedings. And I've done a video on staying proceedings if you want to know what a pause in proceedings or staying proceedings is, and I'll link it in the description area below. So yeah, the defense is concerned about how the grand jury jurors were picked, meaning how were they pulled from the grand jury list from the public settings that they, had they sat on juries before in that same town. They also wanted to know why, when the statute said the number of jurors needed to be called or to be pulled from the public pool was decided by the court, and there was a judge in the grand jury that made an order to issue 45 jurists to be brought in. However, only 32 were brought in, and they didn't know why. So the defense, and this is the defense table, they also want to challenge the DNA evidence. And I've done a video on the DNA I predicted that they would challenge the DNA evidence, because some of the questions that they're raising are some of the same questions and concerns of using familial DNA in. So you can check that out. Yeah, same issues are occurring in the UK. Why they're not convinced. So the defense, so I'm just going back and forth because, like I said, the audio was so bad. The defense feel that this all matters, and as they cannot find any records that explain why 32 potential jurors were pulled and not 45. They say it matters, and they need this information when they challenge the grand jury process. So the defense is also saying that there were irregularities in the grand jury questionnaire forms themselves. For example, not having a jury number on the form. And it is unclear if some were even eligible to serve as a jurist. She gives a few examples, like, were they able to speak and write English? Did they have felony convictions that would prohibit them from serving on a grand jury or a jury? This missing information would confirm, if they had this information, it would confirm if they were eligible to serve. So it is important. Plus, the judge in the grand jury praised jurors after they had voted that there was probable cause to indict. And we'll hear about that more in a few seconds. So the defense wanted these proceedings stayed to allow for an evidentiary hearing to determine if these anomalies would have had an impact on the grand jury's indictment. So the DA, I've also got a little show for you there. The DA responded with the defense to the defense's allegations and said, it is simply the go back off there. Sorry. So they're saying, the defense is just alleging that this smaller number of jurors summoned is lower because of the bias towards the defendant, Bryan Kohberger, and they didn't see any evidence of this. And the irregularities mentioned are not required by the statute. A large number are pulled, and in many cases, the people will give excuses for not meeting the criteria, or be excused for not meeting the criteria. Nor is the information on the Idaho state jury form, that it's just not there on the form in any event. So the state feels that that there is no good reason to stop this hearing because the act does not require the clerk to maintain, for example, the jury numbers and where they sat, nor does the statute compel the jurors to complete the form, as it is the clerk's office that handles those remedial steps, which just means, the clerk would correct anything that needs to be corrected. And the defense has not alleged that the clerk's office did not do this, nor has the defense pointed out that there were any issues with specific jurors. So what do you think? Should the judge have given the defense another pause to get this information? The DA is, let me put them back on. The DA is also saying that the statute, in addition, does not control the behaviors of the jurists or prevent the judge from praising the jurors for serving when they had other obligations. The defense, they doubled down, referring back to their motion and repeated most of what was said again. Well, I don't know about you, but I'm quite curious as to why there were only 32 pulled and not 45 as that could have been potential jurists. And, is this a substantial failure, as the defense points out? Like when there is missing information, the form is supposed to be sent back to be completed. Can we be sure that all the jurors that were in the grand jury were eligible to be on the grand jury? So I can see their point. Now let's go to the judge because he had something to say. The judge did not even hesitate. He said he was not persuaded, and he does not see that there were any substantial failures. Oh boy. And I've also done a video on persuasion. I've done a book review, and if you want to know more about persuasion and persuading the judge to get a favorable decision, then you can check those out, as I will leave those in the description area. But they do really have a lot to do with the evidence before the court. And this judge, let's put him back on, Judge, that's his last name. He said that not all jurors show up, and some of the missing information, he was saying, could have been answered by questions within the grand jury hearing itself. So because he hasn't seen a transcript, he says he doesn't know. He said that he ordered a transcript and to be given to the defense, And as far as he knows, that has been complied with. So, when you think about it, the defense hasn't pointed any of this out or shown any evidence to that. So that's why the judge denied the motion. And he said he's rolling back the original stay proceedings as far as he can see. The trial will start, October 2nd. And I think it's because of this tight schedule that the defense waived their right to a speedy trial, because the defendant obviously realizes that his defense team needs time to prepare. So I can understand the judge's decision. And, for example, in the UK, if a person ignores a jury service notice, they can be fined unless they have a compelling reason. So, plus, should the defense have this kind of detailed information, you would think the process for sending out jury summons is monitored and audited. And nevertheless, the grand jury indictment proceeded with the number of jurors needed. The judge in the Kolhburger case said that they would have to pull at least 1,000 potential jurors for the trial that is going to be starting. I think he actually even said that he has been pulled, his name has been pulled. And so in the recent hearing where the defense has said that they waive their right, well, the judge said he's received a jury summons. So he said, I hope you all agree that it wouldn't be appropriate if he was in there. So I thought that was quite interesting. Though the defense, so let's just show you there, the defense is also arguing that the standard of proof needed for a grand jury is beyond reasonable doubt, not the lower standard to warrant indictment. Yet the state of Idaho says that probable cause exists when a grand jury has evidence before them that a reasonable person would believe an offense has been committed, and the accused party has probably committed the offense. Now, I thought that was interesting because in 1933, the grand jury process in England ceased to function under the Administration of Justice Miscellaneous Provisions Act 1933, and was entirely abolished by 1948. So we don't have a grand jury service anymore. Originally, sorry, I keep saying I'm trying not to, and I just did it. So, originally, so this is, I just can't believe this. Originally, in a criminal procedures, the jurors were informants. Let me just say that again. They were informants. They informed the king's judges what crimes had been committed in their communities. Let me read you a brief statement from Lord Somers, who was considered a high authority upon these points in that time and day. He said, grand juries were instituted to search out, to find offenses, not as merely to put cases in a train for trial. And in his opinion, the grand jury system was, in many cases, an obstruction of justice. So I just want you to keep that in mind, because I've heard this saying in America that with a grand jury you can indict a ham sandwich. So I think that is interesting what Lord Somers said so many decades ago. That's Lord Somers. and how true it could be still today. So I'm trying this recording system on StreamYard. So I'm hoping that it will all turn out right. But anyway, so the grand jury service system was replaced with the prosecution service, and they're independent and they decide on who gets prosecuted. For example, is the defense in the public interest? Is there enough evidence to prove a case? And this is all determined by the Crown Prosecution Service. I've done loads of videos on this, which you can see in my playlist Going to Court, about what the CPS does. So check out those videos if you want to know more about that, because I like to use real life cases to decide these legal procedures and how they kind of, what they mean. So in my opinion, I think the defense, let's show them again. I think the defense is trying to say, now follow my thinking, that they're going to say that the prosecution, there they are, the prosecution was fast to indict, because remember, the prosecution had already planned an indictment hearing, but quickly changed their strategy and rushed off to a grand jury. And remember, that's secret, so nobody knew about it. As there was no evidence, to why only 32 jurists were called and not a bigger pool as ordered by the court, which should have been 35. So, the judge ordered that so that they would have plenty to choose from. And would this make a difference? What do you think? What are the odds that if there was 45 potential jurors that were called, then there could be an argument that there would have been a fair representation of the community. So I think that's what they're going to say, that there was a rush to judgment there. And they're also saying that, this rush to judgment didn't stop there, that law enforcement failed to investigate other known DNA recovered from the crime scene. So even law enforcement was quick to not clear, let me say that again. Law enforcement was quick to clear other potential suspects and fit the circumstances around this defendant, and trying to say he's the one that committed these horrific crimes. And so what do you think? Is there enough reasonable doubt just in kind of those things with the grand jury and, the DNA not of the other victims, or potential suspects not being, looked into? So would they come back with a not guilty verdict? Interesting. One thing I want to point out is I remember I had a case where a person was arrested and they were taken from work. So the law enforcement took all their devices, their phones, their computers, so they had nothing to rely on to see, what they had done, stuff like that. And we've got to remember that an accused is innocent until proven guilty. And it's not the defendant's job to prove that they are innocent. It is the prosecution's job to represent the state. And the state has to prove that the defendant is guilty. So I just want you to keep that in mind as what this defendant was asked to do by a certain time was to provide an alibi within that certain time frame. And the state of Idaho, it was 90 days. And in the UK, it's 28 days if you're before the Crown Court, and 14 days voluntary disclosure if you're in the magistrate's court. So this gives the prosecutor time to investigate witnesses that could collaborate an alibi. And an alibi means that the defendant couldn't have carried out a defense because they were somewhere else. And in my playlist, you'll find two cases, the Lori Vallow-Daybell and Alex Murdoch, where they did give alibis. And what defendants don't realize is that once you give an alibi, then the burden of proof that I told you the prosecutor has, or the DA, is now not only just their burden of proof, it is the defendant's burden of proof to prove the alibi. And we only, if when we saw in the Murdoch case, if you haven't seen that, it's amazing. I mean, just listening to him you just kind of wondered, I don't think that, he's telling the truth. And that's what happens if you take the stand and you can't prove your alibi or anything like that. This just gives nobody will trust you. So to give an alibi maybe isn't good if you can't substantiate it. And this is why I want to tell you about this. So I watched this police interrogation the other day. A guy was stabbed. His name was Kelly Tiller. Ellie was grilling this other guy named Arnold Klein, aka Grumpy. And you can look this up. I'll try to find the link for you and put it in there. But it's brilliant because it illustrates what I'm trying to say. He said he was at the crime scene, and other people said he was there, but he said he was only there to collect his belongings, and that when he left, everyone was alive and well. And he said his wife would confirm it. Unfortunately, for whatever reason, his wife didn't collaborate the story. And this is a long story short, but within about 5 minutes of Grumpy leaving, the young woman that owned the property where the stabbing took place, she had an altercation with Kelly Tiller, the deceased, who she says tried to assault her and attack her. Now, she's saying that she grabbed a knife, and it all happened so quickly that she fled, because after he had pulled the knife out of him, she wasn't sure if he was all right or not. So she ran over to her friends, and had she had not spoken to her friends about what had happened, who knows if she would have ever come clean. Now, Grumpy, this other guy that was the prime suspect, if you watch the police interrogation, you'll see that he could easily fit the bill as the suspect. So it's unfortunate, and because his wife didn't collaborate his story. And from what I understand, Grumpy's wife just got the days mixed up. So here we had the actual person who did it was a woman, but this man, because he kind of fit the bill, was the primary suspect. And all because his wife got the days mixed up. How sad is that? But thank God it was straightened out. And I think the girl got 6 years in prison. So what do you think? Is Bryan Kohberger's team balancing the media frenzy that he is, because everybody's saying he's so guilty before he's even been tried? And I thought it was also curious that the judge said your alibi in quotes, which I kind of thought was interesting, because as far as we know, that is his alibi, that he was driving around aimlessly. And, he has to now substantiate that, or will people believe him? So hopefully I can get your thoughts. And yeah, I've tried this new StreamYard pre-recording. Let's see how it works out. So please leave your comments below, and I'll look forward to reading them, because when this goes live, I can hopefully read them and chat with you at the same time. Okay, thanks. Please like and subscribe.